My Lady, there are a number of points that I need to pick up. First of all, the question of the scope of the Middleton inquiry and how, if at all, it differs from a Jameson inquiry. That's one question. And another question that we touched on before the short adjournment is why it is that we say that these are cases that require a Middleton inquiry. So can I just deal with the first point, which is the content of Middleton and why it was in Middleton that the House of Lords said that the existing practice under Jameson wasn't adequate to deal with inquests where Article 2 was in play. And Middleton is in Volume 3, tab 31. And the point is dealt with at paragraphs 26 down to 38. And
sorry, hang on, it's my fault.
Sorry, tab 31.
Yeah, I know. Yep.
And we're starting at paragraph 26. And at paragraph 26, there's a summary of the effect of the rules, the coroner's rules. And attention is drawn particularly to Rule 43, which gives the power to the coroner, who believes that action should be taken to prevent the recurrence of fatalities similar to that in respect to which the inquest is held, to announce at the inquest that he's reporting the matter in writing to the person or authority who may have power to take such action. So that's the first point under the rules. And then Rule 36, the proceedings and evidence at an inquest shall be directed solely to ascertaining the following matters, namely, A, who the deceased was, B, how, when and where the deceased came by his death, and C, the particulars for the time being required by the Registration Act to be registered concerning the death. Neither the coroner nor the jury shall express any opinion on any other matters. And then Rule 42, no verdict shall be framed in such a way as to appear to determine any question of criminal liability on the part of a named person or civil liability. And it's those rules in particular, Rules 36 and 42, read in the light of the narrow construction adopted in Jameson of the word how, as meaning only by what means and not in what circumstances. Those limits are what gives rise to the decision of the House of Lords in Middleton that it's necessary to read the Act down.
I don't think Rule 42 was being read down, was it? I think Rule 42 stands as it is. What was being expanded on was Rule 36.
Rule 36. But this gives rise to one of the problems, which is what is the scope of the investigation which the coroner can conduct if it's a traditional Jameson inquest and not a Middleton inquest? Because there are some later authorities that suggest that, in fact, the coroner is entitled to investigate all the surrounding circumstances, including system failures. But the clear indication in Middleton is that the scope of the investigation under Jameson is narrower. Now, we understood Mr. Eadie to be indicating yesterday that they were accepting that for the purposes of the death of a service person, the coroner would have the power to investigate all the matters that are set out in Jordan and the UK, including questions of potential systemic failure. And we are wondering to what extent this is perhaps a semantic debate about what is a Jameson inquest, what is a Middleton inquest.
Well, I may have misunderstood, but I thought the Rule 43 had a part to play in that you don't have to put it into the finding by the coroner, but he's got a scope for making recommendations and so on under 43.
Yes, but the point I'm addressing is the problem of Rule 36, that the proceedings and evidence shall be directed solely to ascertaining how, when and where he came by his death, and that the coroner and the jury shall not express an opinion on any other matter. Now, it's particularly this problem about what's the scope of the investigation. That's the central problem. So if we then go on in this judgment, at F and G on page 200, there is a summary of the decision in Jameson and the interpretation of how that was adopted in that case. And that includes the point that a verdict could properly incorporate a brief, neutral, factual statement, but express no judgment or opinion, not for the jury to prepare detailed factual statements. And also, over the page at 201, the last point, emphasis was laid on the duty of the coroner to conduct a full, fair and fearless investigation and on his authority as a judicial officer. And then the question's asked, how does that match up to the investigative obligation imposed by Article 2? And then at paragraph 31, first of all, there's a discussion of criminal cases where there's a not guilty plea. Then at 31, in some other cases, short verdicts in the traditional form will enable the jury to express their conclusions on the central issue canvass at the inquest. And McCann is given as an example where there was clearly an investigative obligation under Article 2, but the short-form verdict was sufficient. But it said it is plain that in other cases, a strict Jameson approach will not meet what has been identified above as the convention requirement. In Keenan, the inquest verdict of death by misadventure and the certification of asphyxiation by hanging as the cause of death did not express the jury's conclusion on the events leading up to the death. Similarly, verdicts of unlawful killing in Edwards and Armeen, though plainly justified, would not have enabled the jury to express any conclusion on what would undoubtedly have been the major issue at any inquest, the procedures which led in each case to the deceased and his killer sharing a cell. And then the conclusion is inescapable that there are some cases in which the current regime for conducting inquests, as hitherto understood and followed, does not meet the requirements of the Convention. And then they consider what they need to do, and at 35, only one change is, in our opinion, needed to interpret how, in section 11.5b2 and rule 36, in the broader sense previously rejected, namely as meaning not simply by what means, but by what means and in what circumstances. This will not require a change of approach in some cases, and this is the point that I was making to your lordships this morning, that simply because you are conducting an inquest under the rules as read down following Middleton doesn't follow that the inquest itself will necessarily be any different. This will not require a change of approach in some cases, where a traditional short-form verdict will be quite satisfactory, but it will call for a change of approach in others. And there's a reference to paragraphs 30 to 31 above. In the latter class of case, it must be for the coroner, in the exercise of his discretion, to decide how best, in the particular case, to elicit the jury's conclusion on the central issue or issues. And then there is a discussion about how that may be done, and there is reference to the Fatal Accidents and Sudden Deaths Inquiry Scotland Act, the 1976 Act. And then at 37, the prohibition on the expression of opinion on matters not comprised within sub-rule 1 must continue to be respected. So in relation to my Lord Brown's question about civil liability, it still wouldn't be possible to express an opinion attributing civil liability, but it must be read with reference to the broader interpretation of how, and does not preclude conclusions of fact as opposed to expressions of opinion. However the jury's factual conclusion is conveyed, Rule 42 should not be infringed. There must be no finding of criminal liability on behalf of the named person, nor must the verdict appear to determine any question of civil liability.
It's tightrope stuff, isn't it?
It is. Indeed, all the case law in this area is complete tightrope stuff, and one is left eventually in a state of complete despair, because this is, in a sense, the starting point, and it gets worse from here on in. At least this is...
Tell me about it.
So we're told that you need to read it down, but that won't necessarily lead to the inquest being any different in some cases, and that you can express conclusions on the facts but not of opinion. And they then give an example of the sort of formula that they're suggesting would be appropriate. So that is Middleton. Now, that of course raises the question, to what extent is there really any difference of substance between the investigation that can be carried out under the Middleton reading and the traditional Jameson, the scope of the traditional Jameson investigation? And that's a question that was considered in Hurst.
Just before we leave this,
Yes.
it seems to me that one of the important things about this speech is implicit. The reference in 36 on the central issue or issues. What is implicit there is that there are going to be central issues, or maybe central issues,
Yes.
which really go beyond the simple questions.
Yes.
And,
Yes.
and the critical thing is,
Yes.
by what procedure do you identify what are the appropriate issues to be investigated?
Yes. Yes. Lord, I would respectfully agree. And of course, in the traditional inquest, the only issue, substantially, is by what means did this person meet their death?
Yeah.
Under Middleton, you're asking in what circumstances, and that means what were the defects in the procedures that may have led to the person getting the drug in the first place that they shouldn't have had, or to the...
Why did an individual commit suicide?
Yes. Was the person who was handling the weapon properly trained?
Yes.
Was their equipment defective? All of those questions. And of course, in the context of this case, the questions one can see going right back to the question of why was he past fit to go to Iraq, given his weight in particular, and the lack of any proper fitness testing, the processes whereby they were given guidance about drinking, which appears to have been inadequate and not suited to the conditions, the lack of the air conditioning unit, the lack of a wet bulb thermometer, lots of instances which, depending on how you look at the scope of the issue, are not relevant. But if we could just go to Hurst. Hurst is at tab 27 in the same volume. Can I also identify to the court, there are two notes prepared on Hurst, one on behalf of the Secretary of State and one on behalf of the claimant, which were prepared for the purposes of the Court of Appeal. Those are in part 1 of the appendix, volume 1, at tabs 10 and 11.
This is the respective parties' notes on hers.
Yes. And, Lords, we would endorse the analysis of Hurst that was undertaken by Mr. Saini on behalf of the Secretary of State as being accurate. But in Hurst, the House of Lords grappled, amongst other matters, with the question whether there really was a substantive difference between the scope of the investigation under Jameson as opposed to the verdict. There was clearly a difference in the scope of the permissible verdict, but whether there was a difference in the scope of the investigation permitted under Jameson and the scope of the investigation permitted under Middleton. And if we go first to paragraph 2, first of all, your Lordships and your Ladyship could see that Lord Bingham agrees with Lord Brown. Then Lord Roger addresses it at paragraph 2. So there was a stabbing in May 2000. Inquest was adjourned, charged with murder, conviction for manslaughter. Coroner was asked to resume the adjourned inquest to investigate what she alleged were the failings of the police and the housing authority to protect her son from Reed. So he had been stabbed by somebody who was alleged to have been threatening towards him. And essentially, she was saying this was an Osmond-type situation, where there had been a failure by the police to protect him against the risk. But this was before the Human Rights Act had come into force. So this was a Jameson inquest. And then at paragraph 7, Lord Rogers says the scope of the inquiry, as opposed to the verdict, is a matter for the coroner. And then he cites Lord Justice Buxton as saying that the chain of causation was too remote, that the questions of the failings of the police and the housing authority were too remote. Then over the page at paragraph 8, Lord Rogers says it's not, this is at B, it's not self-evident to me at least, that any failures by the police to respond to warnings would be too remote to be considered at an inquest, simply because Reed committed precisely the kind of violent act which the people giving the warnings feared would happen. Indeed, uninstructed by the case law, I too might have found it difficult to imagine that a resumed inquest would not examine at least some of the authorities' alleged failures. But I have to accept that the cases show that in relation to Jameson inquests, how is to be interpreted narrowly in both Section 11.5b2 and Rule 36. On that basis, it can be said that the authorities' failures would lie outside the scope of a resumed inquest. So it would appear that Lord Roger is indicating that the scope of the permissible investigation under Jameson is narrower. Then Baroness Hale dealt with it at paragraphs 33 to 34. No, that's not right, sorry, beg your pardon. 19 to 23. And she said, I question whether the distinction drawn by Lord Brown between a Middleton inquest and a Jameson inquest is as stark as he suggests. The Middleton inquest is one in which the Coroner's Act and the rules have to be interpreted and given effect in a way compatible with the UK's obligations under Article 2. She says what that means, and then she refers to Jameson.
I'm sorry, which paragraph?
Sorry, I'm looking at paragraphs 20 and 21. And the analysis goes on to paragraph 23. And that's really the bottom of paragraph 22. She says, although the scope of the inquiry is for the coroner to determine and his decisions will rarely be subject to review, it's difficult to imagine that any resumed inquest in this case would not examine the conduct of the police and the housing authority that fateful day of nothing before. There's nothing in Jameson which precludes or is inconsistent with such a conclusion. All that Jameson precludes is a verdict. So Baroness Hale is indicating that the investigation under Jameson may still be wide enough to include the police failings.
That's a reading of Rule 36.1.
Yes. Now we then come to Lord Brown, and he deals with it at paragraph 48. He says, Middleton clearly accepted Jameson was correctly decided, were it otherwise the House could simply have overruled it without recourse to the Human Rights Act. It's plain the House was not intending the Middleton approach to apply in all cases. In the first place, an Article 2 investigative obligation only arises in the comparatively few cases where the state's responsibility is or may be engaged. Secondly, even where the obligation does arise, it will often be satisfied without resort to a Middleton inquest, in some cases by criminal proceedings, in particular where a defendant pleads not guilty and the trial involves a full exploration of the facts surrounding the death. In others, like McCann, where short verdicts in the traditional form will enable the jury to express their conclusion on the central issue canvassed at the inquest. Why then should Jameson now be reinterpreted? Difficulties with such a proposition seem to be many and various, and he then goes through them and indicates that there is no conflict between Jameson and the United Kingdom's investigative obligation. And Lord Mance, paragraphs 74 and 76, And he says that, like Lord Roger and Baroness Hale, he is not persuaded that the distinction between a Middleton inquest and a Jameson inquest is as stark as I believe Lord Brown to be suggesting. In the light of the reasoning in Jameson and its affirmation in Middleton, the present coroner could not be faulted if he thought a resumed inquest could lead only to a simple verdict of unlawful killing. A quite different matter is the scope of the investigation. And paragraph 76, he again agrees with Baroness Hale that the scope of the investigation could include the wider issues. So, with respect, we're left in this somewhat confused situation, not least because Lord Manx at paragraph 76 indicates that he understands that Lord Roger at paragraph 8 is agreeing that Lord Justice Buxton was wrong to conclude that a resumed inquest could serve no purpose. It's not clear to me that that was, in fact, what Lord Roger was saying at paragraph 8, where he appears to be saying that he thinks it would be relevant, but given the interpretation of Howe and Jameson, he thinks it wouldn't be admissible. So, my lords, we're left in this, I would respectfully submit, unsatisfactory situation where it's clear that on the traditional Jameson inquest, where Article 2 is not engaged, the verdict may not be as wide as it may be under Middleton, but with respect, not clear to what extent the investigation that the coroner can conduct and the issues that he can look at in the investigation is different under each process.
I mean, I accept it too, the scope of the inquiry, I say it in terms at page 215, between G and H is ultimately a matter for the coroner. The verdict and findings are not. That's the difference. Paragraph 51.
Well, Lord, we would be very content if this court were to consider that it was appropriate to clarify, in this case, the point that the scope of the investigation that the coroner may conduct is always going to be wide enough, in any event, to cover the key issues that were identified in Jordan and UK and Armine as being necessary to comply with Article 2. We would be very content for that to be the outcome.
How do we get that? Do we have to read something?
Well,
Where do we get that from? Isn't 36 the problem?
Well, it is the
yes,
problem,
it
my
is
lord.
36. And
36 is the problem, and that's why I understand the reasoning of the majority in Hurst to be that the investigation can't be as wide.
That's what I thought.
But that's the difficulty. Now, that brings me to the position that we have adopted, which is in our submission, given that there remains that tension between the Jameson and Middleton inquest. The question is, what's the right process to adopt in this kind of case? And our submission is that given the fact, first of all, that these are cases where the responsibility of the state will potentially be engaged, secondly, given the fact that this is a case where all or almost all of the evidence will be within the control of the state, and therefore where the facts of the death are very unlikely to be known before the inquest starts. And finally, and this is a point I'm going to return to, given the particular vulnerabilities of soldiers which have been recognised by the European Court of Human Rights, we submit that the right course would be to give clear guidance to coroners that they ought to approach cases of service personnel's deaths on the basis that Article 2 is engaged, and therefore that they have the powers to conduct a wider investigation reading down Rule 36 in accordance with Middleton. Whether that actually makes any difference to the length or scope of the inquest will of course depend on the facts as they emerge at the inquest. So, for example, if there's a single uncontradicted conclusive medical report which shows that the soldier died of a wholly unforeseeable brain hemorrhage, the inquest may be very short. But there may be other cases where the initial facts may not look at all suspicious, but where further investigation may show something somewhat different. And indeed, this case is a good example of such a case. Mrs. Smith was told repeatedly by the MOD that there was nothing untoward about the death of Private Smith. And your lordships and your ladyship may have seen from the facts as we set them out how evidence emerged during the inquest which shed doubt on the picture that had been presented by the MOD. Indeed, Mr. Eadie relied in his list of investigations that had been undertaken on a document called the Learning Account, which was actually the initial investigation undertaken by the MOD following the death. The Learning Account was not disclosed by the MOD for the purposes of the inquest. What happened was that on the last day of the inquest, a colonel who lived in Oxfordshire and who had read about the inquest in the Daily Telegraph appeared at the inquest with a copy of the Learning Account and said, "You ought to see this." And that's how that document emerged. So we submit that it's this sort of episode, and of course the episode, the most striking example of it in this case, is the fact that the whole of the first Board of Inquiry report didn't become, its existence wasn't even known until the very late stages of the inquest. It's those problems with gaining access to the information which we submit, together with the fact that the responsibility of the state is potentially engaged, make it appropriate to say, you start from the premise that Article 2 is engaged. You start from Middleton, you do a Middleton investigation, subject, of course, to the dicta in Middleton itself, that may not mean that you need a longer inquiry or a different verdict. It just means that your powers are read down in accordance with Section 3.
It's helpful perhaps to look at paragraph 35 of Middleton, which is tab 31 in the bundle.
Yes.
Because that just sets out the wording
Yes.
that causes the problem.
Yes.
And
Yes.
for the moment, listening to what you've just been saying, I find it a little difficult to see, unless you do regard it as a Middleton inquiry,
Yes.
that you can get enough information
Yes.
to decide
Yes.
how much further you need to go. Because
Exactly.
if you're restricted to simply to identifying by what means, you get there perhaps in most cases pretty rapidly.
Yes.
Without any indication as to what the underlying circumstances are that might suggest you need to have a wider form of verdict.
I
Is
respectfully
that not
agree.
really the nub of the problem?
It is indeed, my lord. Now, in reality, coroners have been pushing the Jameson inquest to its limits and have been conducting wider inquiries, but that in itself has generated satellite litigation because their decisions to do so have generated judicial review claims saying that the scope of their investigations or their decisions are too broad. And we submit that that could all be avoided by guidance saying, in all of these cases, Article 2 is engaged, Middleton applies, you construe how, as at paragraph 25 of Middleton. And the practical implications of that are very limited, given that these inquests are taking place anyway, and given the factors we've already examined. But the simplification that represents for coroners dealing with these cases, we submit is very great, and it may lead to less litigation, hopefully, in the future. The third factor, I referred to three factors in favour of this being a Middleton situation. The first being that the responsibility of the state is potentially engaged. The second being that the evidence is in the knowledge and control of the state. The third being the special vulnerability of soldiers. And very briefly on that last point, there are two decisions.
Sorry, could you just repeat the three things again? Just so I
Sorry,
know?
yes. The three factors are first, that we submit that all of these cases will be cases in which the responsibility of the state is at least potentially engaged.
Yes.
And that is the only question that triggers the engagement of Article 2. That's the first point. The second is that because of the nature of service life, these are cases where all or almost all of the evidence will be under the control of the state. And that's a point that was made on the Yildiz and which is also made in the custody cases. The third is that we submit there are particular duties on the state towards soldiers because of their particular circumstances and vulnerability. And on that last point, I just want to show the court two authorities. The first is Killinch. We have that partially translated, volume 18, tab 9. You'll see that first of all we have the French text of the meat of the decision, the actual court's assessment, and then behind that, I had it behind on the same staple, there is an English translation.
From paragraphs 40 onwards.
From paragraphs 40 onwards, yes. So, first of all, paragraph 40 is the affirmation of the positive obligation on the state. Then, this obligation applies unquestionably to mandatory military service and implies for states, above all, the primary duty to put in place a legislative and administrative framework aimed at efficiently preventing such incidences. In relation to the specific area in question, this framework must furthermore reserve a singular place for regulation adapted to the level of risk to life that could arise, not only due to the nature of certain military activities and missions, but also due to the human element that enters into play when a state decides to conscript citizens. Equally, regulations require the adoption of practical measures targeting the effective protection of those conscripts who could find themselves exposed to the dangers inherent in military life, and anticipate adequate procedures allowing the determination of the failures and faults that could be committed. Chiefs can't be the right translation there, but anyway, at different levels. And then at 43, in this case, faced with the allegation that the military authorities have failed in their positive obligation to protect the right to life, the court must consider if the military authorities knew or ought to have known there was a real and immediate risk of suicide. Now, I cite that because it's relevant to the submission that Mr. Eadie made, that there was no operational obligation in relation to soldiers, and I'm going to come back to that point later. But the key point here is that there's a recognition at paragraph 41, in the context of conscripts, that both the human element of conscripts because they have been called up, and the particular nature of certain military activities and missions and the dangers inherent in them give a particular responsibility to the state. Now, all we're submitting is that that is a further factor which indicates that it's appropriate to undertake a Middleton inquest. That point was then developed by the court in the context of Article 3, the positive and investigative duties under Article 3, in the case of Chember. Chember is at volume 6. Tab 55, and in paragraph 50, this was a case of a soldier who was punished by being made to do a lot of knee presses and became permanently disabled as a result, and it was said that they'd known that he had a weakness in the knees, and he alleged a violation of Article 3. And at paragraph 50, the state has a duty to ensure that a person performs military service in conditions which are compatible with respect for his human dignity, that the procedures and methods of military training don't subject him to distress or suffering or intensity exceeding the unavoidable level of hardship inherent in military discipline. And then a bit lower down, the state has a primary duty to put in place rules geared to the level of risk to life or limb that may result not only from the nature of military activities and operations, but also from the human element that comes into play when a state decides to call up ordinary citizens to perform military service. Such rules must require the adoption of practical measures aimed at the effective protection of conscripts against the dangers inherent in military life. So again, it's a recognition not only because they're conscripts, but also because we submit the dangers inherent in military life, but there's a special obligation, protective obligation on the state. So, my lords, for all of those reasons, we submit that the right way forward, and the way that avoids the complexity and the invidious distinctions that have, with respect, characterised the case law in this area, is simply to start from the recognition that Article 2 is engaged, and that therefore the rules are read down appropriately. The coroner has the powers to conduct a Middleton investigation and to give a Middleton verdict. And of course, the extent of the obligation he actually needs to perform will depend on the facts of the particular case before him. Yes, a final point on this, which Ms Simon rightly reminds me of, is that under the new regime, this is not in force yet, is it? I don't know. We don't think this is in force yet, but there are projected amendments to the Access to Justice Act, which deal with public funding for advocacy at inquests. This is in volume 15 at tab 122. It's not, I'm told it's not in force. Without turning it up, my lords, I'm aware that I may have outstayed my welcome somewhat, but just for your lordship's note, there is a power to grant legal aid for representation for family members at particular categories of inquests. And the inquests, the categories are: an inquest into the death of a person at the time of the death was detained at a custodial institution or a custody area at a court or police station, was detained at a removal centre or short-term holding centre, transferred or held in pursuant of prison escort arrangements, detained in secure accommodation, was a detained patient, or was in service custody. And then at paragraph 3, an inquest into the death of a person who at the time of the death was subject to service law by virtue of the Armed Forces Act and was engaged in active service. So it's interesting that Parliament itself has recognised that the death of a person subject to service law and on active service should be treated as being in the same category as a death in custody for the purposes of obtaining funding for legal representation. My lords, that's the investigative obligation. Can I now deal very quickly with the question of the existence of a positive operational duty? We respectfully agree with Mr. Eady that this is not an issue that arises in this case. On our submissions, it's unnecessary for the court to resolve it. However, although both sides are inviting the court not to resolve it, Mr. Eady made a number of submissions, and I simply want to indicate very briefly, without fully developing them, that they are certainly not accepted as correct. The proposition of Mr. Eady was that there was no positive operational duty to protect the life of an individual where it was known that there was a real and immediate risk to life in the case of soldiers on active service. And he said that that duty was confined to narrow categories of case, such as the Osman situation, where there was a real and immediate risk to life as a result of the criminal act of a third party, or the situation where somebody was in custody and there was a real and immediate risk of their suicide. We submit that that analysis is not correct, and in fact is a revival of the fallacy that was exploded by the House of Lords in Savage. And without turning it up, Savage is at volume 4, tab 39, and we draw the court's attention in particular to paragraphs 17 and 65. In Savage, of course, it was being submitted that there was no operational duty of that type in relation to those detained in a mental hospital. So it was said that that only applied in custody cases, and those detained in a mental hospital should be regarded as comparable to patients in hospital and not those in custody. And the House of Lords made it clear that you couldn't simply address these cases by dividing them into categories, that the operational duty was complementary to the systemic positive duty under Article 2, and that the two overlapped, and you couldn't say that there was a category where only one applied and one where both applied. We submit that's the analysis that should apply here. Not only that, it is clear that the Strasbourg court has applied the operational duty to soldiers. We looked at the passage in Killinch, that's tab 18, sorry, file 18, tab 9, paragraph 43, which I just showed the court. And Atterman, also file 18, tab 8, paragraph 56, a case where there was actually found to be a breach.
So what were the two references?
The first was Killinch, file 18, tab 9, paragraph 43. The second, Atterman, file 18, tab 8, paragraph 56. And also, as Lady Hale noted yesterday, the same duty has been applied in the context of dangerous activities. That's Honor Yildiz, file 10, tab 73, paragraphs 71 to 73. We also remind the court of the recommendation that we looked at this morning, which makes it clear we submit that the Human Rights Convention applies to soldiers just as it does to others. We accept that the content and scope of the positive obligation will be heavily modified by particular circumstances, and it never requires a state to do more than is reasonable and proportionate. But we submit that there is certainly no authority to suggest that it wouldn't arise in this context. Mr. Eadie relied on the existence of combat immunity as a defence to a claim in tort as being a reason why there shouldn't be held to be a positive operational obligation under Article 2. We submit that that is simply a non sequitur. Indeed, in the police cases, there is no common law duty of care on the police to protect people against the criminal acts of third parties, but there may be a positive obligation under Article 2, and that was explored in the cases of Van Colley and Smith. The final point is that they have accepted the existence of the systemic obligation, and with respect, given the areas of overlap and the lack of a distinction between the systemic and operational obligation, it's very difficult to see why they would accept that, but not the operational obligation. But we do submit finally that the implications of this argument are obviously very significant, and we submit don't need to be determined in this particular case. My Lords, unless I can be of any further assistance, those are my submissions.
No, thank you. Ms. Simon? Mr. Beloff?
My Lord, my Lady, I conceive that I enjoy the role as the only candidate for Best Supporting Actor. And as you will have appreciated from our written submissions, the Commission's support is given to the position of the respondent and not of the appellant. In respect of both the two issues of law raised before the court, we give positive answers, recognising, as my Lord in the chair has observed, that the second question may require modification, but that what we jointly contend for is that the fresh inquest into Private Smith's death must conform with the enhanced procedural obligations from Middleton, which are derived from Article 2 of the Convention. And it's also clear that Miss Rose, quite properly and quite predictably, has, if I may put it this way, plucked the finest fruit from the forensic tree. So I shall seek simply to eschew the wholly inedible, and I'll try within the time available, which I appreciate is limited, to put a few footnotes to the main text of her submissions. In respect of the first issue, which pivots on the meaning of the phrase within their jurisdiction in Article 1 of the Convention, the Commission's broad submission is, were it necessary to advance it in this form, was that everyone within their jurisdiction in that context means everyone under the actual authority of the member state. Now, my lords and my lady, I hope, given the constraints of time, I can avoid, where possible, inviting the court to turn up the authorities, and if I may just, as it were, read into the text the propositions upon which I rely and give the court the references in the volumes. It was in the Uller case, which is in volume 3 at tab 33, that Lord Steyn, at paragraph 29, under a rubric which the court may now feel was somewhat ambitiously entitled Uncontroversial Matters, but in a passage which assimilated and referred to Bankovich, put it in this way: contracting states are bound to secure the rights and freedoms under the Convention to all persons under their actual authority and responsibility, whether that responsibility is exercised within their own territory or abroad. Now, of course, it is not necessary in this particular appeal to travel that distance. A state may exercise its authority over persons because they are located in particular territories, usually but not always within the boundaries of the member state itself. They may also do so because of the relationship that the member state enjoys with those persons wherever they may be located. In our printed case, for convenience, we termed the first territorial control and the second personal control, and in our submission this appeal is concerned with the second. Now, the exercise of personal control could also be subdivided. It could be de facto, which would include unlawful control, and it could be de jure, which would mean lawful control, but de jure too could be subdivided into nationals generally and state agents who will ordinarily be nationals too. And it's the narrowest definition which is sufficient to engage the appellant's convention vis-à-vis Private Smith, who is, of course, a state agent. Mr. Wadham, who is the legal officer for the Commission, as my lord and my lady may have noted from the annex to our printed case, put it succinctly at paragraph 16 in the core bundle at tab 6, British military personnel serving abroad are under the jurisdiction of the United Kingdom government, and the only protection of their human rights during service abroad emanates from the Human Rights Act. It is therefore crucial that the Human Rights Act must be read as applying extraterritorially in such situations. Now, the Secretary of State's concession focused, though somewhat ambiguously, on the fact that the tragic death of Private Smith fell within the jurisdictional scope of Article 1 because the relevant circumstances leading to his death took place within a British Army camp and hospital in Iraq. They added to that as grounds of concession that all times Private Smith was acting within the scope of his duties and that third-party national was involved in his death. It's not immediately clear to us to what extent B and C touch on the jurisdictional issue, certainly in terms of territorial jurisdiction at all. But be that as it may, it was from that premise that the appellants contended that the argument advanced by the respondent is inconsistent with both Bankovich and, of course, Al Scaney interpreting Bankovich in the House of Lords. In our respectful submission is that the appellant ignores the fact that those cases were concerned with what we call the territorial control test and not with the existence or extent of a personal control test at all. Lord Hope drew our attention in the course of Miss Rose's argument to an instructive footnote from Oppenheim. I give your lordship and my lady the reference again on Article Bundle 16, tab 157, footnote 2, where the author said this about Article 1: that provision has been held to apply in various circumstances where a state has exercised authority or control abroad in a manner relevant to the exercise of the right in question. And we would draw respectful attention, firstly, to the notion of various circumstances. So we would say that the concept of jurisdiction in Article 1 is recognised as being polychromatic and not monochromatic, even if there is a dominant colour in the sense of territoriality. And secondly, we draw attention to the learned author's analysis in a manner relevant to the right in question, so that, as we infer, they conceive that tailoring or dividing is not itself always contraindicative of an exercise of jurisdiction within Article 1. Now, my lords, we appreciate, my lady, that Bankovich has been deconstructed and reconstructed in the House of Lords, in particular in Alskane. But it's our submission that it did not purport to provide a comprehensive analysis of the scope of concept of jurisdiction in Article 1. As is so often the case in the Strasbourg jurisprudence, it was an acutely fact-sensitive statement of principle against an unusual background: aerial bombardment, a NATO exercise involving non-convention states, quite remote from the situation where the issue is in relation to what, if any, obligations are owed to a member state to one of its own citizens, subject to a variety of controls both in and off base. My lords and my lady may have noted that in Bankovich itself, in discussing the Cyprus case at paragraph 80, the court said that was an entirely different situation to the present. And we respectfully submit that the same can be said in this case in relation to Bankovich itself. Now, my Lord Roger said in Alskane at paragraph 69 that the Bankovich decision had not lacked for critics. My Lord, that observation, with deference, contained a degree of meiosis. In an article by Mr. Ocades in volume 6 at 153 tab, he lists, and I counted no less than 17 critical articles. My own research has identified that the list is, alas, by no means exhaustive. Indeed, the difficult exercise is to identify an academic supporter of the decision. Now, my lords and my ladies, that may, or it may not, be a testament to its virtues. But be that as it may, we, of course, have to accept that insofar, and I stress those words, insofar as it illuminates the present issue, the Supreme Court will follow it, as did the House of Lords in Alskane. Now, Mr. Edith submitted that it was not for any national court to interpret the Convention in a manner inconsistent with the jurisprudence of the Convention organs. But in our respectful submission, it is equally wrong to reason from the proposition that the Court of Human Rights has not positively endorsed the analysis of the respondents, or indeed the Commission, that therefore this Court is compelled to reject them. If the legal terrain is unexplored, as it appears to be in relative terms common ground, then as long as other factors point in favour of the analysis that we advance, the question surely is not whether Bankovich permits such endorsement, but rather whether it actually prohibits it. And however much Mr. Eadie may emphasise the essentially territorial nature of the jurisdictional scope of the Convention, he cannot escape from the fact that, as Lord Steyn put it in Ur, there is a wider reach, which was recognised indeed in Bankovich itself. And since our case is founded on the exceptions to the essentially territorial scope of the Convention, we are not at all embarrassed by Mr. Eadie being able to say with perfect sincerity that we cannot rely on arguments based on territorial control. Our submission is that whereas Bankovich was the first major case in which the meaning of jurisdiction was addressed by the Grand Chamber, we know it has not been the last. There is Öcalan, there's Ilescu, there is Issa, and there is most recently El Sadoun, all of which present, except perhaps the last, some difficulty to those who argue that Bankovich is a comprehensive statement or creates some kind of legal straitjacket. The position is rather, we would submit, that Bankovich said the first word Different factual circumstances have engendered different responses, and as my Lord Coates observed, on the 9th of June, we may yet get further learning from the Court of Human Rights. Now, in our submission, the interpretation of the concept of jurisdiction in Article 1 as extending beyond territorial control and into the personal control such as a member state exercises over its armed forces is supported by, or at the least not inconsistent with, 8 matters, each of which I can deal with very briefly. The language of the Article 1, the object and purpose of the Convention 2, the travaux préparatoire, language 1, object and purpose 2, travaux préparatoire 3, jurisprudence of the Commission 4, jurisprudence of the Court of Human Rights 5, jurisprudence of the House of Lords 6, international jurisprudence 7, and comparative domestic jurisprudence 8. But before embarking, as I submit briefly, on developing those propositions, we submit that it would actually be surprising if the state were not obliged to accord convention rights to members of its armed forces wherever they were deployed in right of their status as such, because there is no segment of the population, it may be prisoners apart, over whom the state exercises such a degree of control. Members of the armed forces have relinquished near total control over their lives to the state, and this applies whether they are home or away. We set out the mechanisms of control in paragraph 24 of our printed case. Miss Rose has given your lordships and my lady a more elaborate exposition of them, and our forensic point of departure would be that it's counterintuitive that the relationship of the Crown's armed forces to the state should be unilateral. Because unless the concept of jurisdiction in Article 1 had a purely territorial dimension, which it does not, those forces are, on any ordinary meaning of the word, subject to the jurisdiction of the United Kingdom. We quoted from an academic commentator in our printed case who put it elegantly, where prescriptive rules are applied, so should be protective norms. This was Mr. Arnell. It's volume 14 at tab 141.
141, did you say?
I think it's one.
16 at 141.
Volume 16.
141.
Yeah. Because, as follows from Miss Rose's exposition, we submit that none of the contraindications for the assertion of jurisdiction which one finds in the Strasbourg jurisprudence are in play. First, there can be no question of the grant to our soldiers in Iraq by the United Kingdom of convention rights as constituting an interference with the sovereignty of any other state. No other state contends for such sovereignty. Secondly, there can be no question of us as a convention state seeking to impose convention standards on non-party states. Thirdly, there can be no question of applying the convention to the acts of states who are not party to it. Nor indeed do we seek to argue that anyone who is adversely affected by an act imputable to the United Kingdom would thereby ipso facto be brought within the jurisdiction of the United Kingdom. That would be to amalgamate two distinct issues and to reason backward, and a submission to that effect was rejected in Bankovich at paragraph 75, and we do not repeat it. So I turn then briefly to my 8 headings. Firstly, Article 1. It is concerned with the relationship, not with the relationship between states and with their respective legal competencies. It is concerned with the applicability of a human rights treaty to given state conduct towards individuals. It's concerned not with when a state may lawfully exercise its legal authority over a particular situation, but its responsibility for acts which may be lawful or unlawful. See Bankovich in particular at paragraph 70. Now, paragraph 57, which has been cited to you in Bankovich, the court said that it must, and I quote, take account of any relevant rules of international law, then with this proviso, remaining mindful of it, that's the Convention's, special character as a human rights treaty. So our submission is that certainly jurisdiction ought to have no more limited a meaning that it bears in international law, but there may possibly be occasions deriving from that special character in which the concept is given a wider meaning. Now, the phrase within their jurisdiction, in one sense, sets limits to a state's obligations, but in another merely marks out its extent. We submit that it could be viewed as having an inclusive dimension. But what is indisputable is that it is a word with a wider reach than the merely territorial, and the French version, relevant de la jurisdiction, makes the point still more emphatically. It could have been qualified, the concept of jurisdiction, by concepts of territoriality, but it is not. It speaks about persons, everyone within their jurisdiction, and not about everyone within their territory. And there are many examples in human rights treaties which use the concept of jurisdiction and territoriality differently. If I may give my lords and my ladies simply two, Article 2.1 of the International Covenant on Civil and Political Rights, which we have in volume 15 at tab 130, confers jurisdiction to all individuals within its territory and subject to its jurisdiction, which uses the concepts conjunctively, but by referring to both, recognise that they are distinct, otherwise one or other would be OTOs. Another example, which we have in the same volume at tab 129, the Convention on the Protection of Human Rights of All Migrant Workers and Members of Their Families of 1990, uses the concept within their territory or subject to their jurisdiction. Here the concepts are used disjunctively, but again their distinction is recognised for the same reason. So that's what we say about the article. Secondly, object and purpose. This is the primary rule of construction according to Article 31 of the Vienna Convention, which we have at volume 15, tab 31. It is a human rights treaty. It is susceptible to a generous construction, and there are multiple references to that effect. What Lord Steyn said in Brown and Stott, which we have in volume 1 at tab 4 at page 707, that of the two principal objectives of the Convention, the first was to maintain and further realise human rights and fundamental freedoms. One may also cite, and I just give, if I may, the court the references, what the Court of Human Rights itself said in the Jordan case, volume 4, tab 72, at paragraph 101, and McCurr at tab 81 at paragraph 103, and then most recently Al Sadoun in volume 18 at paragraph 127, and I quote if I may, the court must in addition have regard to the special character of the Convention as a treaty for the collective enforcement of human rights. Now we submit that by itself this justifies an expansive, not a restrictive construction of the concept of jurisdiction, even if Bankovich has ruled out an evaluative in construction which is applicable to the substantive articles of the Convention, but is said in that case not to be appropriate to an article which defines the extent of the Member States' obligations to accord those rights. So we simply say, without trespassing in territory that we are forbidden to trespass by Bankovich, a generous construction can be derived simply from object and purpose. I go to Travaux at 3. Here the terrain we accept is somewhat less firm.
Somewhat what?
Somewhat less firm for our purposes. The Travaux, but Mr. Eady referred to them, so we must, if we may, grapple with them briefly. They are a subordinate means of interpretation, and they are less compelling than object and purpose. If my lords and my lady will, for this purpose, conveniently go to volume 16 of the bundle of authorities, and go to tab 151. This is an article authored by a Professor Lawson, and I should immediately make it clear that he is party pre in the sense that he was one of the counsel for the unsuccessful applicants in Bankovich, but I use him not for that purpose because he conveniently aggregates at pages 88 to 89 two extracts from the Travo, one of which only was cited in Bankovich. That is the one that one finds at page 89, and Mr. Eady referred to this and suggested that the phrase within their jurisdiction was merely intended to enlarge the concept of residence in a particular state to physically being within a member state. Our first response is that if that was what was intended, the article could easily have been drafted to say so, and it did not. And the natural inference may be, if I can use a sporting metaphor, that the member states in fact overbumped. They went further, as it were, than that aspect of the Travo prophesied that they might. Secondly, in any event, on its face, it says no more that the benefits could be extended to all persons within the territories of member state. It does not say that there are no grounds for extending it further. Thirdly, the main focus of the Convention is obviously on rights to be enjoyed within the territory of member states, and the Travo in the passage quoted addressed that point. But what Professor Lawson points out, and I take you back now, if I may, to another part of the Travo, which is at page 88, where he refers to the governmental subcommittee and refers to, since the aim of the first RL amendment is to widen as far as possible the categories of persons who are to benefit by the guarantees contained in the Convention, and since the words living in might give rise to a certain ambiguity, then the proposal is to replace the words residing with by within its jurisdiction. But if that was, as it were, part of the philosophy which animated the drafting, one notes widening as far as possible the categories of persons who are to benefit by the guarantees contained in the Convention is obviously hostile to any notion of a restrictive territorial definition. And finally, of course, and the fifth point is that whatever the Travo may say, Bankovich itself recognised that there was an extraterritorial reach to a member state's obligations, so that Travo certainly, even on Bankovich analysis, did not compel a narrower definition.
Is there a reference to paragraph 73?
Yes, it is indeed. Yes. It's 90 to 73. Then can I then fourthly go to the Commission's case law, and here in the same volume, I trust, at tab 147, one finds the most recent edition of Harris, O'Boyle and Warbrick's Law of the European Convention on Human Rights, published last year. It's not without interest that one of the authors or editors, as my lords and my lady will see, is Mr. O'Boyle, the Deputy Registrar of the European Court of Human Rights, who is the only person who's authored an article which is actually supportive of the Bankovich decision. Be that as it may, what he says in his editorial capacity here is not uninteresting. If you go across the page to 804, it's under the rubric, the concept of jurisdiction in Article 1. The concept of jurisdiction, the editors say, has been the subject of a long evolution in the case law of the Strasbourg organs, though the clearest expression, and I emphasize those words, the clearest expression of the concept has come in the cases they have heard involving Northern Cyprus. Now, what is interesting, I pause there, is to note that the editors obviously do not regard these earlier cases from the Commission as being in any way obsolete. They're part of long evolution, but nonetheless, the clearest expression of the concept they detect is to be found in those cases. Now, they then cite, of course, the passage from Cyprus and Turkey, which Miss Rose cited to my lord and my lady, which contains the concept of inter alios armed forces remaining under jurisdiction of the state when they are abroad.
Sorry, did you tell us the date of this?
209.
2009.
Now, the case which is cited really is authority for two propositions. Firstly, obviously, that there is no rigid territorial limitation and jurisdiction which reflects the boundaries of member states. And secondly, and pertinent, of course, to this appeal, that the state's armed forces are within the jurisdiction of the state wherever situated. Now, there have been a variety of other cases in the bundles where exactly the same formula is used. I'll just give you again, if I may, the references. Chrysothemos and Turkey, which is at paragraph 9 in volume 6 at tab 56. Cyprus and Turkey, volume 6, tab 58, paragraph 20. But unless, again, one might be tempted to think that it was the peculiar situation in Cyprus which led to some deformation of the jurisprudence, there are equivalent cases in other geographical areas, and they are also cases that cannot be confined within what one might call the exercise of consular jurisdiction, which were the ones which were analysed in the divisional court in Al-Skaini. W and Ireland has been read to my lords and my lady. That's in volume 12 at tab 102. There are two further ones that were not read, both of which are in quite distinct factual circumstances. One is Verncombe against the United Kingdom. That's in volume 11 at tab 99, paragraph 14. Here what was in issue was nuisance by noise from a shooting range, which was part of Her Majesty's property, and the complaint was of breach of the neighbours' Article 1 First Protocol rights and their right to respect for their private life. And Stocker, which is in volume 18, tab 6, paragraph 166, here a German national who was in France was tricked by the German authorities into flying in an aircraft supposed to take him to Luxembourg, which in fact took him to Germany, where he was promptly arrested. So one has, as it were, a sequence of cases, not all concerned with Cyprus, and certainly not all concerned with the exercise of consular authority, all of which repeat the concept that armed forces remain under its jurisdiction when abroad. Question: does Bankovic override this line of authority? And in our respectful submission, it does not, and there is no indication that it did. If you go to Bankovic now, if you'd be so kind as to go back to that, at bundle 5 at tab 47. These cases are referred to only indirectly in paragraph 69, where there is a debate about the proper analysis of the Drozd case. They simply say Drozd cited a number of admissibilities by the Commission. They don't say which would now be regarded with suspicion or departed from or anything of that kind. In our submission, they left those untouched. There was no need for them to comment on that line of authority, since on no view was personal control in issue in the Bankovic case. What is interesting is that in Issa at paragraph 70 and in Al Sadoun at paragraph 85, the court returned to and made reference to, at any rate, some of the Commission cases, not, as Lord Mance was astute to note, those ones which contain the phrase upon which we place reliance, but that was, as Miss Rose explained, simply because that was not a matter which they needed to address in that case. So in our submission, these line of cases have never been dead and buried by the court, and if they were, they've triggered some or enjoyed some marvellous resurrection in the later jurisprudence. So fifthly, the jurisprudence of the court. Bankovic was a territorial case, control, or it was nothing. The Serbian victim could not, by the most imaginative argument of an advocate, be identified as subject to the jurisdiction of Belgium and 16 other states, other than by reference to the argument which failed on territoriality. And Miss Rose has taken you to paragraph 30, which epitomises or summarises the argument that was made on behalf of the applicant unsuccessfully. Bankovic referred to the territorial jurisdiction as being primarily paragraph 59, essentially paragraphs 61 and 67, notably paragraph 66 and 80, and exceptional the other bases of jurisdiction, paragraph 61 and 71. But the first set of adverbs recognises that the jurisdiction under Article 1 can have an other than exclusively territorial dimension, and the fact that the other bases of jurisdiction may be exceptional does not mean, of course, they do not exist. On the contrary, it is a recognition that they do exist, and we repeat, we're concerned here not with the reach of the primary jurisdiction, but with the reach of the exceptions. The respondent's submission, summarised at paragraph 34, is breast high with the case that Ms. Rose and I are advancing, and we draw attention to the fact that there is no indication in the court's judgment that they disagreed with the way in which the respondents put the matter. It's nowhere suggested the concession was extravagant or unwarranted. The respondent government indeed accepted a personal control test, and they used it to juxtapose to the territorial control test, which they were manifestly able to persuade the court could not succeed. In referring again, if I may, just on the language of Bankovic to the other bases of jurisdiction in 59 and 73, again Miss Rose has taken you to these, but can I just draw your attention to the fact that the word including is used in both of those particular paragraphs. So even those are not, on the face of Bankovic, exhaustive. And when one comes to paragraph 80, one notes that the last sentence in that page...
Which page?
Page 23, paragraph 80. Accordingly, the desirability of avoiding a gap or vacuum in human rights protection has so far been relied on by the court in favour of establishing jurisdiction only when the territory in question was one that, but for the specific circumstances, would normally be covered by the Convention. I draw attention again to the word so far, which appears to recognise the possibility that in the future there may be further extensions. And even the conclusion of the court itself is significant. Was not in paragraph 82 therefore persuaded that there was any jurisdictional link between the persons who were the victims of the act complained of and the respondent states. Did not say that they were not persuaded there was any territorial link between the persons who were victims of the act complained of and the respondent states. And the ordinary reading of that paragraph in our submission would be that we have two competing arguments, the applicant's argument on the one hand, as it were a territorial link, the respondent's argument on the other, control over persons owing some form of allegiance to the state, and we decide that neither of those two are here satisfied. So in our submission, Bankovic is entirely compatible with the case that we advance, certainly not hostile to it. Now, in Issa, of course, there were further problems, but not entirely germane to these, but again appears to be a retreat to a broader version of jurisdiction espoused by the Commission in earlier cases. But more important in our submission is Ocalan, which you have at volume 10, tab 24, paragraph 91. You will remember that this involved the arrest by members of the Turkish security forces inside an aircraft registered in Turkey, but in the international zone of Nairobi Airport. In no sense was there territorial control by Turkey over that particular zone in that particular airport. The fact that there was a violation of convention rights could only be based on a jurisdictional concept that involved personal control, and that what was said in that case at paragraph 91 was this: it is common ground that directly after being handed over to the Turkish officials by the Kenyan officials, the applicant was under effective Turkish authority and therefore within the jurisdiction of that state for the purpose of Article 1 of the Convention, even though in this instance Turkey exercised its authority outside its territory.
What inference do we draw from the comment of the Grand Chamber in Bankovic about that case and Issa?
Well,
however, in neither of those cases was the issue of jurisdiction raised by
the answer to that is that at that stage, it had only, this was not a question about admissibility at this particular stage. This case then went to the full court, and that, as I understand it, I'd be corrected if I'm wrong, as I understand it, post-dated the Bankovic decision.
Yes.
That's right.
Yes.
And yes, I'm consoled by that. Can I just deal very briefly with the tailoring issue? The points that we make in response, in addition to those made by Ms. Rhodes, are these. We say that the state must grant its soldiers convention rights wherever situated, but that doesn't necessarily mean that they have to be granted all rights in every place. And where jurisdiction arises from personal, not territorial control, it should not be assumed that the jurisprudence applicable to the latter can be granted without modification to the former. Secondly, and in any event, we know from Ilascu that the court has taken a more nuanced view to whether or not one may modify the degree to which one must provide certain protections or guarantees than it appeared to have done, at any rate in the Bankovic situation. Thirdly, we have the illustrations given by Ms. Rose in relation to the limits of what consular officials are expected to do, which were approved by my Lord Brown in Alskyne at paragraph 130, and the result of that analysis in our respectful submission is that the convention cloth can be cut to suit the type of cases which fall outside the territorial jurisdiction cases. Another illustration, of course, is from Uller itself. The different obligations that this court and the House of Lords previously have had to consider when one is concerned with, on the one hand, so-called domestic, and on the other hand, so-called foreign cases. And we respectfully submit, if one goes back to Bankovic itself, the argument that was being advanced by the applicants was that one must be able to reason from an alleged violation of human rights, thereby to establish jurisdiction. And it was in that context that this argument as to tailoring was deployed by Bankovic. And in our submission, they were not there saying that an adjustment of convention rights to particular circumstances is never permissible. They were saying only that it is impermissible to contend, as the applicants do, that one can reason back from an alleged violation of human rights to establish jurisdiction. So penultimately or pre-penultimately domestic jurisprudence. I think Baroness Hale, my lady, has already acknowledged that in the Gentle case, she herself, at paragraph 60, this is volume 2, tab 25, suggested that if Mr. Musa detained in a military detention facility in Baza within the jurisdiction, then a soldier serving under the command and control of his superiors must also lie within the jurisdiction. And the rationale that my lady gave, which we respectfully espouse, is this: the United Kingdom is in a better position to secure him all his convention rights, modified as their context is by the exigencies of military service, than it is to secure those rights to its detainees. And my Lord Brown, in the Al-Skaini case, at paragraph 140, asked the question, what object would be served by construing and applying the Act so that convention rights only take effect where the result of the violations is actually felt in the United Kingdom? And that was clearly, as my Lord put it, a num, not a nonny question. It expected the answer no, and indeed if one reads paragraphs 138 to 139 and 141 for your Lordship and my lady's note, you will see why Lord Brown was able to reach that particular conclusion. Finally, on Al-Skaini, what we simply say is that the concept of jurisdictional link that my Lord Roger embraced is in fact a reflection to the word of what was said in the ultimate paragraph on Bankovic. And of course the debate is as to what Bankovic meant, to which you, my lords and my lady, have my submissions. The fact that it is an exceptional jurisdiction only is a reflection of the trite and obvious fact that the vast majority of violations of human rights will occur within a state's own boundaries. What we say is it would be contrary to logic and indeed paradoxical if the activities of British soldiers were considered capable of conferring jurisdiction on non-nationals by virtue of the soldiers' link with the United Kingdom, but the soldiers were not themselves considered within the jurisdiction of the Convention for the purposes of the Human Rights Act. And the Secretary of State says non sequitur, and we respond equally with Latin, we say e fortiori. On Gentle, we want to say no more than is set out in our printed case at paragraphs 26 to 27. We do, however, among the many points we there make, do remind, my lords, that Lord Bingham himself had been in a minority in Al-Skaini in denying any extraterritorial effect at all to the Human Rights Act. That was at para 26 of his judgment or speech in that case, and therefore one must be very cautious in attaching comprehensive assent to everything that he said to the other members of the House. Seventh heading, international jurisprudence. I referred earlier to the position in relation to the International Covenant of Civil and Political Rights. Now, on the face of that document, one might have thought that a construction would be given since it referred both to being within the jurisdiction of the court and to persons who may be within their territory, that this was, as it were, a double hurdle over which a claimant had to leap. But on the contrary, in the case that we referred to in our printed case at paragraph 35, we draw attention to the fact that the Human Rights Committee itself determined that they should be read disjunctively, or rather that they should be read as meaning that one should provide the rights to all persons who are within their territory, and one should also provide rights to all persons who are subject to their jurisdiction. Now, this was quoted in Bankovic, this provision in paragraph 26. The case, the Lopez and Uruguay case, was dismissed somewhat cursorily in paragraph 78 as being the solitary example of the committee reaching an interpretation of that kind. One wonders, with great respect, whether the fact that the House of the Supreme Court simply pronounced on a single occasion was meant to undermine its authority. But what Bankovic did not refer to, and in our respectful submission, is very important, is what we cite at paragraph 36 of our printed case from the general comment of the Human Rights Committee, which in volume 15, tab 138, states parties are required by Article 2, paragraph 1, to respect and to ensure the covenant rights to all persons who may be within their jurisdiction and to all persons subject to their jurisdiction. This means that the state party must respect and ensure the rights laid down in the covenant to anyone within the power or effective control of that state party, even if not situate within the territory of the state party, which would certainly, as a matter of ordinary language, embrace the armed forces of the state, who are manifestly subject to its power and effective control, and indeed to its legal control. So what one has here is the Human Rights Committee giving an appropriate, expansive interpretation to such an instrument, not two hurdles which needed to be surmounted, but two gateways through which only one, a claimant, need pass. Finally, comparative domestic jurisprudence, and again we've cited certain authorities in our printed case. I really want to refer, if I may, simply to one paragraph of the decision of the Supreme Court of Canada in the Cook case. Just again, for my lords and my ladies' note, this is volume 14 at tab 114, and I cite it because the Supreme Court there said this: law enforcement officers acting in their official capacity are state representatives who are authorized to give effect to coercive state power, in some instances at great personal risk. As a result, they undeniably owe allegiance to the state and may expect a corresponding right to protection. On this basis, the two Vancouver detectives in this instance can be considered Canadian nationals, thereby justifying extraterritorial assertion of jurisdiction. What one derives from the approach in that case is, it is because they are authorized to give effect to coercive state power at great personal risk, owe allegiance to the state, that is the genesis of their entitlement to a corresponding right to protection. It epitomizes, better than I have been able to do, the essence of the argument that we advance on Article 1. If I may, 2 minutes or so on Article 2, in which Miss Rose has said virtually all that needs to be said. The Commission's position, again, the emphasis is given in Mr. Wadden, its legal officer's affidavit or witness statement annexed to our printed case in tab 6. The entitlement to an enhanced investigation is of particular importance in such cases where legal aid for participation of families in proceedings is limited. The need for transparency and involvement of relatives is crucial to such an investigation. In particular, one may add, obviously, that it should be an effective investigation, that it should result in accountability if accountability is required, and it should provide an education to avoid any future lapses from appropriate behaviour. Now, we've set out in paragraph 43 a series of cases in which we say the enhanced obligation referred to in Middleton should be applied. The most controversial issue is clearly the question of a soldier in combat. We associate ourselves with Miss Rose's position. We say you start from Middleton and then you restrict if it is found that restriction is required, since the case is entirely clear, whereas Mr. Eady puts it the other way around. You start from Jameson and you expand. We do say that Article 2 enhanced obligations are triggered because there is a potential engagement of the responsibility of the state. The answer to Lord
Mr. Bell, what's it mean in practice between those two? What's the difference in practice?
I suspect the difference very much is funding at the outset and the way in which, as it were, the coroner lays the ground for what he is going to do. I just wanted to, in a sense, that what obviously concerns my lords and my lady, and rightly, is what are the implications of this. And we would respectfully submit that there are, putting on one side derogation, there are three controlling factors. The first is that the case, alas, will often be obvious. Either it will be, as Miss Rose said, a brain hemorrhage entirely unrelated to anyone's fault, or it will be a situation in which it is quite clear that wholly properly equipped soldiers were sent on a military mission, and as Lord Mant says, in those circumstances, although the responsibility of the state is potentially engaged, because one wants to be certain they have the right equipment, they weren't sent on some mission equivalent to the charge of the Light Brigade or something of that kind, but in the majority of cases, as it were, it'll stop there. Secondly, the concern about whether the coroner will seek to trespass into operational areas, as it were, of military tactics. Can one just say this about McCann? My Lord Walker raised the question about how tender the Court of Human Rights had been to the shooting in Gibraltar. If you look, and I'm not asking you to look now, at tab 11, at paragraph 200, what you will see is, with all the other criticisms that are made, the court respected the fact that in a military situation, often urgent decisions have to be taken that may indeed be mistaken. And there is a series of cases that were brought to mind while the argument was advancing, but unfortunately aren't available in the bundles, in which I'm familiar, where police have unfortunately shot someone whom they believed to be armed but was not. I'm sure my Lord Carr remembers these cases. Again, when the case was taken to Strasbourg, the Strasbourg court recognised that mistakes can be made in those kind of situations. So that's a second controlling factor. And the third one...
What was the reference you gave? You said
the
tab
McCann
11.
200, the Gibraltar case.
McCann. Yeah.
It's volume 9, tab...
Is it?
You're sure that's the right
You said
one?
111.
That's the Gibraltar one? Yes, well, I'm told it's tab 80, volume 9. Anyhow, it's paragraph 200
Yes,
is the one that
that's
I
right.
wanted. The third controlling fact is this. What Middleton has done is to say that both in respect to the Act and the rules, the word how must be given a meaning beyond by what means and go into in what circumstances. One bears in mind that the rule itself is prefaced by the word solely, so it is in fact on its face restricted and it points in a restricted direction. But it's a question of construction. What is meant by in what circumstances? Now, this court will be very familiar that both in private law, where one is concerned with the ambits of a duty of care, or in public law, when one's concerned with judicial review of an administrative decision, the courts have constantly reiterated that it is not their function, it is not within their competence to make judgments on issues of allocation of scarce resources. And in our submission, if a coroner construes in what circumstances in the conventional way, there is no risk that he will need to inquire into whether money could have been better spent on A than B within the military budget, or indeed between the military budget and other budgets. What he will, of course, be entitled to do and to examine is to whether or not the equipment itself was satisfactory. After that, it'll be a question, no doubt, for the legislature, questions in the House and the like. So we respectfully submit that those three controlling features mean that this isn't, as it were, to open up some kind of Pandora's box in which the public interest will be overwhelmed by giving proper effect to Article 2. And we do point out that insofar as there are budgetary considerations concerned, Parliament has already recognised in legislation which is not yet in effect, but will be in effect, that where persons are relatives of serving soldiers who have died, they will be given public funds for that purpose. To say that Article 2 requires as much at this stage in our submission is not something that is manifestly contrary to the public interest. Unless I can assist my lords, my lady, further, I am at least within the hour that I will.
Well done, Mr. Bennett. Thank you very much.
My lords, my lady, I will be brief for two reasons. Firstly, we are at the end of the third of three potentially relatively long days. And secondly, whatever I say now will be said in the lustre of Mr. Bellow's advocacy. It might be said that it's some years since he could properly have been described as anything other than a leading actor. On jurisdiction, first of all, whether or not the ECHR is unique or has an autonomous concept within it. My submission remains the same submission as was made in the Alskeni case, as one sees, for example, from pages 166H to 167A in the Divisional Court's judgment and the note of argument before the Divisional Court. My submission remains
Pages again, I'm so sorry.
166H
Yes.
to 167A in the Divisional Court's judgment in Alskeni. Namely, that the Article 1 jurisdiction concept is an autonomous concept with a meaning specific to the Convention. That concept, as all other concepts in the Convention, is to be construed applying the approach in the Vienna Convention as outlined in the Bankovich case. So one is to have particular regard to the language used, to the drafting history and the travaux, and to state practice. And none of those, in my respectful submission, provides any support whatever to the suggestion that the concept of jurisdiction, as used in Article 1, was intended to be exactly equivalent to the concept of jurisdiction as it might be used in various forms elsewhere in international law. On the contrary, if one focuses first on the language, if the drafters of the Convention had wanted to say that it means exactly the same thing as the concept of jurisdiction wherever else it might be used in international law, they could, and it might be thought would, have said so, and they did not say so. They used instead the concept of within the jurisdiction, when they had available to them, for example, the concept of in all the circumstances in the Geneva Conventions, as I outlined in opening. The language we respectfully submit is inconsistent with the proposition that any base, any jurisdictional base in international law will do. And as is clear, jurisdiction as a concept under international law can be limited and for specific purposes, whereas the language in the Convention requires the states to secure the rights and freedoms set out in the Convention to those within its jurisdiction.
Would you accept that the argument put in paragraph 36 is an example of state practice of the 17 states involved?
In paragraph 36
yes,
of?
Which is of Bankovich.
Well, my lord, it's an argument run. It was an argument run by the United Kingdom to provide contradistinction to the situation it's an argument run by the United Kingdom in that case, and provided a contradistinction to the situation which existed there. I wouldn't accept that that represents state practice.
But isn't it? I mean, your argument's slightly paradoxical because you rely heavily on Bankovich, but actually, Bankovich adopts international law as the guiding theme in its interpretation of the scope of the Convention.
Well, my lord, in my
paragraph 59 onwards.
My lord, in my submission, it doesn't equiparate whatever jurisdictional base one can find in international law with jurisdiction under the Convention. What it says in Bankovich is that state practice is relevant to that issue, But essentially what it says is that the concept of jurisdiction has to be construed in harmony with international law and or in conformity with it. See paragraph 57 in particular. If one is looking for state practice, the state practice that paid or that the European Court of Human Rights gave particular weight to is a state practice to which they refer in paragraph 62 of Bankovic, to which reference has been made on a number of occasions, including its reference to the state practice of all states not derogating in relation to military operations abroad, including, for example, in the Gulf. And again, there is nothing in straight state practice, we respectfully submit, and no one has suggested it, that would support the proposition that they considered that the meaning, any meaning of jurisdiction in international law should thereby be taken as being equivalent to the meaning of jurisdiction within the Convention. And again, they could easily have said so. They didn't say so. And the absence of such state practice is of some importance, we respectfully submit. And the Travaux are to the same effect. There is nothing in the Travaux that would support the proposition. We've been to the Travaux for different purposes, but there's nothing in the Travaux that would support the proposition that the drafters of the European Convention were purporting directly to equiparate any basis of jurisdiction under international law with the concept that was being used in Article 1.
So how did they expect somebody who read this convention on the day after it came out to know what was meant by the words within their jurisdiction?
Well, my lord, they would construe the provision exactly in using exactly the tools that the Grand Chamber used in Bankovic. They would go to all the tools. They would go to the language, to the Travaux, to state practice if it existed, which it didn't, I fully accept, the day after the convention was signed. They would no doubt place reliance upon the existence of alternatives, such as in all the circumstances that appeared in the Geneva Convention signed up to the year before. They would use the traditional tools for interpreting
Would they
treaties.
have any regard to what was meant by jurisdiction in international law?
My lord, they would. And you can no doubt be guided by that. The question, however, is not whether international law might provide some guidance to the concept. I don't for a moment seek to say that it wouldn't provide some guidance. That would be wholly inconsistent with, for example, paragraph 57. The proposition that I'm seeking to meet is the proposition that says, which is the foundation of the case against me, if you can find a jurisdictional base in international law, that in itself is sufficient for the purpose of Article 1. They are to be regarded as exactly equivalent. And that is not what the European Court said in Bankovic, in my respectful submission. See in particular the very careful language that is used in paragraph 57, which culminates with a reference to being in harmony with international law. And that is a very different proposition. That's not saying it's the same as, and if you can find a jurisdictional base, that's enough. It indicates rather that the approach to or the interpretation of jurisdiction under Article 1 mustn't lead to a conflict with internationally recognised reaches of jurisdiction. So you couldn't arrive, it wouldn't be appropriate to arrive at an interpretation or an application of Article 1 jurisdiction that, for example, required a state to interpose itself to provide, for example, protections for its citizens that were inimical to local law. That would not be in conformity with international law. It would not be consistent with it. So we don't accept the core proposition that as long only as you can find a jurisdictional base under international law, and there are plainly some, for example, long-arm criminal jurisdiction, military discipline that attaches to forces and so on. But we don't accept the proposition that as long only as you can do that, that answers the question so far as the ECHR is concerned. Fundamental to the concept of jurisdiction in the ECHR, properly construed in my respectful submission, is the proposition that one cannot divorce the concept of jurisdiction from the concept of securing the rights and freedoms. And in order to, the core aim of that provision is to ensure that you can secure the rights and freedoms. And that does necessarily raise, when considering jurisdictional issues, it does necessarily raise the practical and principled restraints that might fall upon you in any particular given situation in securing those rights and freedoms.
I suppose that's why you would say the words "as far as possible" are used at the end of 57.
Yes.
As far as possible in
Yes.
Parliament here.
And we also submit, although it is an ambiguous concept, that it explain what they mean by taking into account its special character as a human rights treaty. Of course, normally that concept is used in an expansive sense, but in this context, it could perhaps be seen as recognising the need to secure all the rights and freedoms, because that is, after all, what Article 1 provides. That's the obligation that flows from a conclusion that someone falls within the jurisdiction. Secondly, therefore, in relation to the submissions made by Ms. Rose, is it enough for it to be shown that the state is exercising jurisdiction in the sense recognised by international law? We say no. We say it's a different question. The ECHR meaning is autonomous, and this is the essential building block for her argument. She says the army is exercising jurisdiction in senses recognised by international law, therefore soldiers are within. But the intermediate step, in my respectful submission, does have to be recognised. If she is right, the necessary intermediate step in her reasoning is that the army, qua state agent operating abroad, can, by exercising powers, bring others, that's third parties, within the jurisdiction. And that is precisely the position that was argued for on precisely the same authorities that have now been relied on time and again here, Cyprus and Turkey and those authorities, precisely the same argument that was relied on in the Al-Skani case by the claimants.
The rubric that a term must be given its autonomous meaning features frequently in the jurisprudence of the European Court of Human Rights.
My Lord, it does, in a variety of contexts.
Has it been applied to within the jurisdiction?
I don't know of a case in which that has been used, but it may be that the use of it in the other contexts, was what led Professor Greenwood to use that concept in his submissions, as we see recorded in Al-Skani. Obviously, in relation to other the rights and freedoms themselves, it simply denotes that you're not bound by the domestic law characterisation.
I understand the concept on it, but I was wondering whether it had been given expression or found expression in any of the judgments of the court.
I don't think so.
It can't mean anything else, can it?
It can't,
I mean,
in this
it simply refers to the fact that it's an international phrase and is not intended in some individualistic domestic law sense. But going back to your point on the third parties, I mean, I think the answer which would be put is that we're not talking about third parties, we're talking about the state and its relations with very junior branches of the state, the army. So it's not a question, as it was in some of the earlier cases, of bringing third parties within. It's simply a question of carrying the state abroad.
My Lord, I understand that, but a part of the reasoning which is deployed does rely upon the fact that they are acting qua the state. They are acting as state agents, and there is therefore an equivalent personal jurisdiction to the personal jurisdiction which is exercised by state agents over third parties that is being deployed now in relation to this other context. That's the short point I make. Question then whether Bankovic affected the older commission cases, and in particular also whether Al-Sadoun is, as I optimistically suggested, for me, or as she suggested, for her. My lords, my lady, on Bankovic, we respectfully agree, and I'm not going to go back to it, we respectfully agree with the divisional court. It was, for the reasons that they gave, both a watershed and a rationalisation of the previous case law. And so it's not possible simply to trot out the old case law and take an expression of the broad principles set out in them on their face. See in particular paragraphs 259 to 60 in the judgment of the divisional court. they noted in particular that there were a series of doubts about those older cases, and noted also that they'd been rationalised differently as the jurisprudence stream progressed. See in that respect 269 to 274 in the Divisional Court's judgment. So far as Cyprus and Turkey is concerned, that was the start of that line of authority. That was the first time that the phraseology which both Mr. Beloff and my learned friend Miss Rose have relied on, that was the first time that was used. It was the first time there was the reference to diplomatic agents and armed forces and so on. And it is notable, we respectfully submit, that thereafter, at least for a brief period of time, that was simply the mantra that was trotted out in other commission cases in particular. But we invite you to note that at the source of that line of authority, no authority was cited for the breadth of the proposition that featured in the relevant paragraph of Cyprus and Turkey.
No authority cited for what?
No authority was cited for the breadth of the proposition that was cited in Cyprus and Turkey.
Well, it was even broader, wasn't it?
It included
further observes that nationals of a state,
exactly,
including ships and aircraft, are partly within its jurisdiction.
Exactly. That's paragraph, I think, 131 of the Divisional Court's judgment.
135.
Yes.
Nationals vanished very quickly from the picture.
They did, and armed forces, it might be thought, swiftly followed
behind.
It may also be, if you're in the Divisional Court judgment, noting paragraph 172 in this context. Which I think is a point that was picked up in argument, although it obviously occurred to the Divisional Court as well. Namely that although the Commission relied upon that broad statement, that didn't feature when the matter got to the court. And indeed the basis on which jurisdiction was founded in the Cyprus and Turkey decision thereafter came to be analysed in a very different way, in effect as effective control of area. And we note, in particular, that when Bankovic arrives, the equivalent phraseology does not include armed forces and only includes the diplomatic agents and others. So far as Al Sadoun is concerned, which is to some extent related to this point, that's at bundle 5, tab 44. A learned friend relied upon paragraph 85 in the court's judgment in that case. That recites a list of authority for propositions uncontroversially set out in that paragraph from the Bankovic decision itself. Again, it's in standard form. Most of the court's judgments are cast in this form. General principles are collected together and set out in more or less general form, with a citation of a mass of authority to support them, built up over the years. And then what really matters, however, is the way in which the court then disposes of the particular case, having regard to those general principles. On no view does that recitation amount to an endorsement of a theory of personal jurisdiction based on the exercise of authority by a state over its armed forces. The critical indication of approach, as I indicated in opening, in my respectful submission, is in 88 and 89 of that judgment. And Ms. Rose simply didn't address in her submissions those paragraphs, but they are the dispositive paragraphs. They answer the question why, or on what basis, was it that Al Sadoun was within the jurisdiction. And if she is right, the reasoning should have been that the army are state agents exercising powers recognised by international law. or treaty or customary international law. That indeed, as isn't denied, was precisely what was argued. See paragraph 73. So it wasn't as though the argument wasn't squarely before the court. There is nothing whatever resembling anything like that in the paragraphs which actually dispose of Al-Sadoun. On the contrary, as I indicated in opening, that is based squarely on the reasoning in Al-Skaini. Essentially territorial, Hess is cited, specific endorsement of the judgment of the House of Lords in Al-Skaini. The question then, the next question is whether or not the embassy cases provide a stepping stone to the proposition that all soldiers are within the jurisdiction wherever they may be. The reasoning process appeared to be that diplomatic agents can bring other individuals within the jurisdiction. They can do so in relation to specific functions that are exercised, so you don't need to worry about indivisibility of rights, securing all rights to third parties and so on. You can tightly restrict it, so he can bring a third party within his jurisdiction. But then, even though you don't need to worry about indivisibility for that purpose, runs the argument, it follows that the person exercising that authority is himself within the jurisdiction for all purposes. And the state is obliged to secure all the convention rights to that person, the diplomatic agent, wherever he may be in the world. And then essentially the same reasoning is applied to soldiers. And we respectfully do not accept that it's legitimate to reason back in that way. It goes from the specific narrow basis for bringing third parties within the jurisdiction for limited purposes, connected, as Lord Carr rightly pointed out, with the function, to the much broader proposition that the diplomatic agent himself is for all purposes within the jurisdiction wherever he may be. The latter question is not answered by the former. In relation to the latter question, it is appropriate to have regard to the controlling principles we respectfully submit, including the essentially territorial nature of the convention and the nature or the ability in principle and in fact of the state to secure the relevant rights and freedoms to that individual. Moreover, it's to be noted that if that is the end point of the argument, as it is, namely that the state is obliged through this process of reasoning to secure all the rights and freedoms to diplomatic agents, for example, because they wield some state authority for some purposes, the respondents cannot avoid properly having to grapple with problems of indivisibility and through them with delivery. Can those rights properly be secured to diplomatic agents simply by virtue of their status wherever they may be in the world? The second objection to that reasoning is that, in my respectful submission, it's not appropriate or permissible to use the narrow exception to draw out the general principle. If one seeks to do that by relying on diplomatic agents and the cases in which they exercise their narrow powers, one inevitably moves swiftly into authority and control territory as a freestanding principle. And that was the argument run in Al-Skaini and rejected in Al-Skaini. More generally, perhaps it's another way of putting the same point, but one can't use the exception in effect to undermine the general rule, namely the centrality of the territorial concept of jurisdiction in this convention. Put another way, one cannot, through the purported creation of an exception, undermine the core principles themselves. And that, as we understand it, was the point that was being made by Lord Brown at paragraph 127 in the Al-Skaini case in rejecting the argument that there was a freestanding principle based on authority and control. At 127 of Al-Skaini, where he said, alternatively, it would stretch to breaking point That is, if you accepted personal jurisdiction based on authority and control. Alternatively, it would stretch to breaking point the concept of jurisdiction extending extraterritorially to those subject to a state's authority and control. It is one thing to recognise as exceptional the specific narrow categories of cases I've sought to summarise above. It would be quite another to accept that whenever a contracting state acts, militarily or otherwise through its agents abroad, those affected by such activities fall within its Article 1 jurisdiction. Such a contention would prove altogether too much.
Sorry, what paragraph?
Paragraph 127,
Okay.
halfway through. So that was the first way in which my learned friend put her case, that the position was equivalent to diplomatic agents, and the reasoning process for diplomatic agents worked in that way. Her second position was that the position of a soldier was in any event like that of the third party who was affected by the diplomatic agent. If so, in my respectful submission, that would apply to others who are subject to similar acts of legal authority. The reasoning is that an agent of the state, it appears the MOD or the commanding officer, is exercising authority over a third party, here a soldier, and it's the act of exercising that authority that brings him, the soldier, within the jurisdiction.
Well, you accept that on the base.
We accept that on the base we do, but not as a general proposition off base, no, for the reasons given in Alskany. And my submission is that that way of putting it is essentially the same when the acts are as agent of the state in relation to any third party. It's the act of authority that creates that link, if that's an appropriate link to create, not degrees of control. So it doesn't make any difference if the soldier is subject to greater degrees of authority and control, because it's the act of control over the third party which is the focus. And on that basis, if that reasoning works, why wouldn't it cover Baha Musa off base? And why not others? And that was the principle of authority and control run in Alskany, page 160, and rejected by the House of Lords. The House of Lords didn't say it depends on the degree of authority and control you wield or the nature of the link. The House of Lords simply say, well, that's the wrong test. Essentially and centrally, it is a territorial concept subject to very narrow exceptions, and you can't use the exceptions to undermine the core principles. And indeed, it might be thought that if it did all turn on degrees of authority and control, that the position of a soldier was rather less severe in terms of the degree of authority and control as compared, for example, to a prisoner off base. Then to the issues surrounding whether or not the rights can indeed be secured, if my learned friend's argument is accepted. Her argument, it's to be borne in mind, is that the diplomatic agent, the soldier, and indeed, although she didn't address it, it appears from the logic almost all, if not all, state agents wielding some form of authority, state authority abroad. She says all those categories of people benefit from all the rights and freedoms in the Convention, wherever they may be in the world, simply by virtue of their status as state agents wielding some form, however limited, of state power. And in those, it's perhaps to be borne in mind also that as her submissions progressed, it became clear that she was not seeking even to draw a distinction between off-duty and on-duty. So it's anywhere in the world by virtue of status, on duty or off duty if you're a soldier. And in those circumstances, the marketplace in Rangoon, the souk, as I think Lord Hope put it, is a real situation.
But I'm sorry, I mean, all they've got to do is to tell you not to go there, or, you know, only to go there in some particular vehicle or something like that. I mean, they don't have to, any more than if you're in barracks in Belfast. I mean, what's the difference?
Well, my lord, in my situation, it is an impossible obligation. because the delivery, as I indicated in opening, of the rights and freedoms in the Convention often will require a thing which existed in Belfast and doesn't exist here, in our context in Iraq. It will require a framework of legislative and executive control that is simply absent off base in foreign countries.
You don't accept, then, that it's good enough to say that's a no-go area. We can't provide that, so don't go there. That's where you can't exercise your rights at all. I mean, that's our advice, and that's the best we can do to give effect to the Convention rights.
My Lord, that's extraordinarily difficult in my submission. That involves chopping the rights up, and the assertion that is made against me is that all rights have to be secured to all soldiers, wherever they may be in the world, whether they're on or off duty. And it's the logic of that which needs to be examined in assessing whether that is truly the position. But as I say, if you need a framework of legislation and executive control as you do to protect most of these rights, then you necessarily have both the practical difficulties that would flow from dealing with freedom of speech in the souk or whatever it may be, and you have the principal difficulties that you are necessarily abutting into territory which is occupied by another state's sovereignty. And that is intensely problematic. And it is for that reason, for those sorts of reasons in my submission, that in Bankovich the Grand Chamber described the Convention as not being designed to be applied throughout the world. And why in the specific context of Iraq, Lord Roger rightly described it as being absurd to suggest that Convention rights could be secured in the utterly different cultural and legal society that is southern Iraq. And it is no answer to that point in my respectful submission to say, well, there are cases which indicate that military duties may require some alteration of rights. We accept that principle, of course. Sen and Engel and that line of cases, and indeed I'm sure if we end up back in this court arguing about combat immunity, I will be relying heavily on Sen, Engel and other cases. But they're no answer to this difficulty because they don't address the fundamental problem which flows from the argument, namely the necessity to give any real content to any number of rights, including Article 2 procedural rights, to give any content to those rights, you need a framework of legislative and executive control, which is simply absent. And it's not enough to say, well, look at paragraph 2, you can in some circumstances, subparagraphs of the relevant qualified rights, you can in some circumstances be justified in not according them. The reality is, as Lord Phillips noted in the opening submissions, that in this sort of context you would end up in a whole variety of situations which it wouldn't be difficult to envisage, given the expansive notion of some of the rights and freedoms, for example, in Article 8. It would be not difficult to posit a series of situations in which applying subparagraph 2 to limit them would simply be no more than saying we can't properly afford or secure those rights. Take Article 2 procedural. There's plenty of authority in standard language, now standard language, that says you've got to do a variety of things in terms of your Article 2 procedural obligation, including punishing those who are responsible for the death. Now, how does that work in a context such as southern Iraq, where there is no off-base, where there is no framework of legislative or executive control? British police don't operate there, and nor could they, in principle. We come back finally in relation to jurisdiction to the precautionary approach that I started my submissions with. There is no convention case which holds or indicates that a soldier is covered in this way wherever he may be in the world, on or off duty, carries the backpack of rights around with him. There's no convention case which decides that. The high watermark, as it was put by Lord Brown to my learned friend, the high watermark of my learned friend's case is being able to point to obiter comments in the Cyprus and Turkey cases, Those obiter comments were then dropped in subsequent cases, and indeed Cyprus and Turkey itself was rationalised on an entirely different basis, namely effective control of the area. And we do submit, for all the reasons that were set out, both in the speeches of Lord Brown and of Lord Roger and of Baroness Hale in Alskane, we do submit that the precautionary principle is an important one. You shouldn't, for all those reasons in the context of Article 1, go further than it is clear, or than it is inevitable, to use Baroness Hale's words, from the jurisprudence in Strasbourg. Article 2, then, very briefly. Our inquiries are still not entirely complete, but it appears, and it's right that I should tell the court, two things. First of all, we have laid hands on, as the initial stage in the investigation at least, a letter which was sent out to persons such as Private Smith. I can't say it was sent out to him, because it is a standard form letter, but it indicates, that the first stage of the process, as I indicated to you before, is to request volunteers, followed up by the compulsory notice which is necessary for the purpose of protection of various rights. So that is the standard form letter, and it contains, it's right also to point out on the second document, Form 1, which is to be filled in by those who are prepared to volunteer. That's, as it were, the good news from my point of view. The bad news is that, having gone through his file, at least the file held at the MOD, there is no record of either the standard form letter having been sent to him or the return document coming back from him. If that position changes, then we will, of course, inform the court. So it is not currently clear whether or not that occurred, but my instructions remain that, as a general matter, although there are certain specialist disciplines in relation to whom no option was given, so if you're a doctor or whatever they were short of, you were simply called up compulsorily, in relation to most ordinary soldiers, including soldiers such as Private Smith, who were being used to infill where there were gaps within regiments, my instructions remain that there were very few, if any, or there was precious little, if any, need simply to go to compulsion. There were sufficient volunteers.
Well, the first paragraph of the letter that we have seen that was sent to him records that the decision had been taken to mobilise compulsorily elements of the reserve forces.
Yes. And then they asked for volunteers in order to meet that. So the decision has been taken.
Not in this letter, did they? No, I'm talking about the letter sent on the 2nd of May 2003.
Oh, I see.
Private Smith.
Yes. I mean, there's no doubt that is a compulsory notice.
Yes.
The only question is whether it was preceded by...
Volunteer to be compelled, or you're compelled to volunteer? Which way round is it?
Well, that depends on... I mean, that would be a starker question. If the answer to the numbers question was that in a particular category there were not enough volunteers. And there is the possibility within the system to appeal against the notice of compulsory call-up. But I fully accept that if the position was that the numbers of volunteers didn't work, then this point would go nowhere. I mean, maybe a point of very little substance anyway, but it appears that for some people, and we can't establish one way or t'other in relation to Private Smith, volunteering preceded the compulsory notice. My Lords, my Lady, just to reiterate very briefly our position in relation to Article 2, we respectfully submit that the content, rather than the trigger, is the key. We respectfully don't accept that one can simply proceed from an acceptance that the trigger is relatively light to the proposition that the content has to be Middleton. The two don't follow. Our basic position is that the coroner can and should proceed on the Jameson basis, that will be sufficient, save in rare cases.
What does that mean? I'm very puzzled with this.
Well, my Lord,
you start off with what you've got.
Yes.
And what you've got may tell you straight away that this is going to be an extensive inquiry where there are issues that go beyond what one might call the conventional inquest.
Well, of course, there will be certain cases where on the material that is gathered together at any point in time, it is tolerably clear that one has the sort of issues that we discussed. I'm not going to go back over. Tolerably clear that you have the sort of issues that would call for Middleton. Well, if that is the position, as I understand the current practice, it is to have a pre-inquest hearing to determine the nature of it in most cases. You can have an argument about that. If it's tolerably clear that those issues arise, it obviously doesn't make any sense to say Jameson, then Middleton. But my submission is that if there is doubt about that, you start off in the manner prescribed by the statute, which is to answer the narrower set of questions, and if and only if issues then develop which indicate that it needs a broader inquiry, do you go there?
Well, do you accept that the coroner at the outset should at least turn his mind to the question whether it should be a Middleton or a Jameson inquest?
My Lord, I do. I think that would be a thoroughly sensible thing for him to do. And as I understand it, in most cases, that is the practice.
At the outset, is it? You said a pre-hearing.
I'm told that the normal practice is nowadays to have a pre-inquest hearing, which will consider, I don't think it occurred in this case, because Article 2 was only raised at the very end of the inquiry.
Well, whether it was or whether it wasn't, I think the coroner should have turned his mind to it on his own initiative, should he not? I mean, he's got to at least ask himself whether he's got a Section 6 obligation, and he can only embark upon that if he asks the question. It may be that he will say, well, I can't tell at this stage.
I certainly wouldn't dissent from that proposition. We're all aligned, at least in this, that the position at the moment is a very, very difficult one for coroners to deal with. We're all aligned around the proposition that it would be a thoroughly desirable thing, if the court felt able to do it, to give as uniform a guidance as was possible as to how they should go about doing it. And as part of that, I certainly wouldn't dissent from the proposition that it would be a thoroughly good idea, if not an obligation, I think is the point you're putting here, on the coroner, to consider at the outset whether or not it should, from the outset, be a Middleton inquest or a Jameson inquest. I certainly don't seek to dissent from that proposition. And I don't dissent from the proposition that my Lord Phillips put to me, which is that if it's tolerably clear at the outset that those sorts of difficult issues arise, then one can proceed straight to Middleton and not bother about anything else. We just have more difficulty with the proposition that one should, as a matter of, as it were, practice now, or a matter of guidance from this court, say that in all cases you should start from Middleton and then work backwards. That, in my submission, is a difficult proposition, not least because there will be some cases where it is entirely clear that those issues don't arise. Take the case where someone dies of appendicitis in a military hospital, and there's no difficulty or issue about that.
It would perhaps be odd to resolve it all by reference to the legal aid position, but the fact is, as we're told, unless you do start as Middleton, you don't get legal aid. So if you then change your mind and you say, well, now it's got to be Middleton, I mean, then you've got to delay everything. Well, legal aid.
My Lord, with respect, that's simply not accurate.
Oh, what's wrong with
that? Is simply not accurate. As I understand the position, the legal aid decision is made not simply on that basis, it's made on the standard basis of means and nature of issues. And my understanding is also on instructions that all the inquests that occurred pre-Smith were Jameson inquests of a similar type involving British servicemen's bodies being flown back into the jurisdiction. They were all Jameson inquests, and in relation to all of them, the relatives received legal aid. So we do not accept the proposition that that the legal aid issue flows simply from the characterisation of this as a Middleton inquest or a Jameson inquest.
My Lords, I'm so sorry to interrupt, but I must put on the record that that is disputed,
Is there
factually.
some way in which we can get accurate information about this? Because for myself, I wouldn't want to guess at this at all.
Well, we will
Could we
produce
have
can I suggest this? We will produce a list of those where we say that's happened, and my learned friend can produce a list of the cases where she says it did all turn on Middleton. And if that
And
is,
chapter and verse, please, as to what basis there is for taking the decision.
of course, we can certainly do that, I'm sure, and if we reach a middle position, so much the happier. But there certainly have been some, if not every single one. There certainly have been some, as I understand it. Indeed, the Gentle case itself, I think, was an example.
That is certainly potentially a very important distinction, whether you're going to start off with
Legal aid or not.
legal aid.
Well, then it's important that we have the facts entirely accurate, and those are my current instructions, but I will absolutely make sure that we have chapter and verse on that.
It's slightly wagging. I mean, it's obviously a very important point, but the scope of the international obligation is can hardly depend on domestic legal aid. It may be that domestic legal aid ought to depend on the scope of the international obligation.
Quite. My Lords, there is another potential difficulty with just simply starting with Middleton, which is that a Middleton inquest does require a reading down, as my Lords have already noted and are now well aware of Rule 36. And that is only appropriate in circumstances where otherwise, or where it is necessary to do that in order to secure convention rights to people. And if it is not necessary, and that indeed is the cast of the new legislation which is to come in 2012, as I understand it.
Unless we were to decide afresh what's meant by how.
Well,
That would then have to apply to everybody.
that would then have to apply to everyone, and then you do run into the difficulties. What is as I understand the problem in Middleton, it was that the House did not feel able, using conventional canons of interpretation, to reach the point of which, the point of width, that they thought was necessary for the purpose of securing convention rights. It was for that reason that Section 3 was deployed. But as I understand the reasoning of the House in Middleton, it was only through Section 3 that in what circumstances could be introduced, because it effectively involved going beyond the recognised meanings. I mean, my learned friend Miss Rose and I are as one on the how in practice it's been developed on the ground. It is perhaps to some extent unfortunate that the coroner is not here and represented to make submissions to you about precisely how they do go about doing things in practice. But as we both understand it, every effort is made to not to, as it were, run up against an artificial limit even within the Jameson language. And this inquest itself, I'm not going to go back to it, but you saw the summing up that I took you to. And there is considerable flexibility to allow them to do that, as that indicates. And so the position is not perhaps as dire or as problematic as my learned friend indicated, not least because of Rule 43, which you've seen. And no one, I think, has suggested, it was a point made in Tecutius, that however you construe the concept of how, what you can't do is to construe that concept. I think it's a point my Lord made in the Court of Appeal in Jameson. You can't construe that concept so as to undermine Rule 43. So the scope of the investigation that is undertaken by the coroner has to be at least as wide as is necessary to enable him to make a proper judgment about whether or not Rule 43 recommendations should be made, and if so, what they are. And in this case also, as you will have seen from the summing up, Rule 43 was operated by the coroner. He drafted a letter and sent it.
It wouldn't be very easy for us. I know the 2009 Act is not in force, but it wouldn't be very easy to reinterpret the scope of the word how, now that the legislator has specifically distinguished how from in what circumstances.
Right. There may be a I entirely accept that. There may be a host of legal, interpretive and constitutional difficulties with an approach that says you can just reinterpret how. So a decision does have to be made, and a decision has to be made at some point. But at least, as it were, the gap has narrowed in relation to Jameson. Part of the reason for my learned friend saying go straight to Middleton is because of her assertion that Jameson was actually very, very narrow. We submit that it's not as narrow as she would have you think. But we respectfully say that I'm afraid you are saddled, and so are coroners, with that distinction, and you will be saddled with it under the new Act. So there will have to be decisions. The only question is how one goes about making them. What is the sensible and appropriate way of doing that? And in relation to that, we do respectfully submit, for all the reasons I was given, that Jameson must be the starting point. There will be some cases in which you can say immediately, let's go straight to Middleton, but in cases where you can't, go as far as you can with Jameson. Everyone recognises that the issues are less stark, at least in relation to investigation. Go as far as you can. If you are butt up against a place where you want to go and you don't feel you can go on how, at that point the issue would have to be readdressed. But it might be thought that at that point the issues would have become a great deal clearer because you would have pursued, as it were, the Jameson paths. And it may also be that the approach for which we contend has the added advantage of dealing with, I know, the problem that Lord Brown is exercised by and was exercised by in Hurst, namely the difference as a matter of law between the permissible verdicts or end results of these inquests. But by that stage, if that is really where the pinch point lies in terms of the difference between Middleton and Jameson, because the investigations can be at least very similar, if that is truly where the pinch point lies, at least at that stage, it will be pretty clear what the evidence looks like, what the shape of the issues look like, and so on. So that would be a natural point to readdress it.
I mean, if the great moment comes when light goes on and the coroner says, it's Middleton, what outward and visible signs are there that that's happened? I mean, what happens? I mean, when that's gone on in his brain. But the people sitting there, do they suddenly realise, gosh, it's Middleton? What happens?
I can't guarantee that level of stunned reaction from the audience. My Lord, at that point, he says, I mean, if the approach which I'm advocating is adopted, he will reach that point not, as it were, sub silentio and as a matter of enormous surprise to himself and others. He will reach it because he has pursued the Jameson avenues as far as he thinks permissibly he can, and he's reached a point where he thinks, I need, in order for this to be effective, and for taking into account all the other facts I indicated, I need to go further. I need to go into this area, which I don't think I can do if I'm how, but I think I can do if I'm in what circumstances. And the appropriate course then would be to invite submissions from anyone who is before him and make a judgment about whether or not this was an appropriate case for doing that. That does at least provide a sensible and informed basis on which that decision can be taken. And as I say, the matter can be kept under review, and the natural point at which it would then next be readdressed would be when the evidence was in and he was thinking about the form of verdict. But as I say, even there, and it might be a downside because it might lead to confusion, but I mean, even there is considerable flexibility. Narrative verdicts can be given in relation to Jameson. You've seen the form in which it happened in this inquest. You've seen the 8 pages of reasoning that preceded it, with a short statement of conclusions on the relevant issues. In neither case is it permissible for the coroner, neither Middleton nor Jameson is it permissible for a coroner to go on and give the impression that he's determining civil or criminal liability. Of course, we recognise that in Scotland they have a better system, at least in relation to the 1976 Act, in allowing them to look at defects under that legislation, but the differences aren't so great.
I mean, you could have a situation on your approach. He starts Jameson, goes to Middleton, then the point fizzles out. So he goes back to Jameson.
Well, I mean,
or indeed another scenario. He goes to Middleton. Somebody doesn't like it, and they challenge it.
Well, it sounds unsatisfactory, but it's not as absurd as it may sound, in my respectful submission. I mean, take, for example, the issue here about the type of thermometer. I forget what type of thermometer it was called that was said was not there. Wet bulb thermometer. Suppose, for the sake of argument, that he thought, well, wet bulb thermometer is very interesting, I'm going to pursue that down. I'm worried about how far I can go with that. But supposing then he received expert evidence, or in cross-examination an expert said, well, actually, it really would have made absolutely no difference. It would have been a thoroughly desirable thing to have in practice, no doubt. But I can tell you that wet bulb thermometers only go up to 45 degrees centigrade, and actually throughout the entire period it was 50 degrees. I mean, it is entirely possible that an interesting issue fizzles out in the course of the proceedings. And so the shape of where he needs next to go, whether he needs to pursue that further or whether he can rein back in, is a fluid one. That is to acknowledge no more than that issues change during the course of a process, and that it is appropriate that courts and coroners should be able to react to that. But in my submission on this point, it appears really that the only point that is now dividing us, and it is a narrow one, is whether or not in giving the guidance you should say to coroners, in any case involving a serviceman, you need to go straight to Middleton. And we say there are difficulties constitutionally with that, there are difficulties in terms of interpretation with that. We say there are difficulties because certain deaths will be clear at the outset, appendicitis in hospital, whatever it may be, or even, take an example I think Lord Mance raised, someone who is just simply shot by the enemy, where there is absolutely no doubt about that. In those cases, there is no need. A Jameson would plainly be enough. All we're saying is you need to take it by degrees. Of course, that leads to a need to draw lines, but at least
theoretically, it wouldn't be enough. Theoretically, body armour missing, no body armour. Shot by the enemy.
And I must say, I don't think that death by appendicitis in a military hospital is a particularly good example of one which obviously calls for no further investigation. But there it is.
Well, one can posit whether
Think of something a little more serious than appendicitis, from which people do die.
Well, just a heart attack.
Right.
Yeah.
You know,
Anything.
I mean,
Any cause of death which is uncontroversial. I apologise for the examples where controversial rather than uncontroversial, but an uncontroversial example, the most uncontroversial one can think of.
it's a bit like Rangoon.
I promised last night to my team I would not go back to Rangoon. I think I mentioned it once, but no more. Well, can I just check whether there's anything else that anyone wishes me to say before I finish? Unless I can assist further.
No, thank you. The tragic death of Private Smith has given rise to difficult and important issues of law. We're grateful to counsel for their assistance and will reserve our judgment.
My Lord, I'm so sorry. The question of obtaining evidence about legal aid at these inquests, my instructing solicitor tells me that it will take some time to gather material.
There will be some time for you to do that.
Yes, I'm told it may take as much as 6 weeks because of the interposition of Easter. I hope that's not going to be a difficulty. We will try to do it sooner if we can.
Try and do it a little sooner than that.
I'm grateful.
Perfectly timed.
It's the only thing you can do these days.